Good morning, everyone, and welcome to today's webinar entitled Consent to Intervention and Advanced Care Directives Act. My name is Annette Johns, and I'm the Associate Director of Policy and Practice with the Newfoundland and Labrador Association of Social Workers. I will be your moderator for the session this morning. This is a topic that is of great interest to social workers, and we have over 180 members from across Newfoundland and Labrador tuning in today. As noted in the 2018 NLASW Standards of Practice, social workers must be familiar with the laws and regulations relevant to their practice and comply with provincial and federal legislation that is applicable to their practice. The Act respecting advanced healthcare directives and the appointment of substitute healthcare decision makers is an important piece of provincial legislation that social workers need to be aware of and is a great topic for today's webinar. This webinar is a collaboration between the Newfoundland and Labrador Association of Social Workers and the Canadian Association of Social Workers. The webinar presentation will be approximately 60 minutes, followed by a 30-minute question and answer period that I will moderate. Please send in your questions throughout the presentation. Only myself and the presenter will see the questions. All of the housekeeping details you need, like how to access the recording and where to download the slides, are all included in the housekeeping widget that popped up when you first logged in. Members may claim 1.5 CPE hours for this session under the required category of workshops. I now want to introduce our speaker, registered social worker Deborah Perry. Deborah is the risk management consultant for Eastern Health here in St. John's. She provides leadership and expert consultation and advice on the identification of, elimination, and/or mitigation of risk through the implementation of evidence-based patient safety practices and sound risk management strategies. She is a subject matter expert in integrated risk management for the organization, which has over 13,000 employees. Deborah's educational background includes a registered nurse diploma, Bachelor of Social Work, and a Master of Social Work in Policy Administration. She has been employed in hospitals, community, and government agencies over the past 25 years. Deborah has completed certifications in Risk Management and Safety and Health Services, Canadian Healthcare Association and Clinical Risk, Negligent and Claims Management in Healthcare, Usgat Hall Law School. She is a current member of the National IRM Advisory Committee through HIROC. Welcome, Deborah, and I'll now pass things over to you to begin the presentation.
Good morning, and thank you, Annette, for the introduction, and good morning, everyone out there. It's great to see such a great uptake on folks that are registered this morning. I want to does everybody see my slides? Okay, all right, so we have I think I'll start off with the three objectives, which will take us through the morning and hopefully get some good questions generated, and I will be speaking to some of the core concepts of consent within the context of the Advanced Healthcare Directives Act. And I know from working in practice, and particularly in discussions with social workers, this is a topic that we engage in many discussions about, and what are really the components of the Act as it relates to healthcare decision making, and as social workers being critical parts of the team, the healthcare team, what does that mean? And I want to talk a little bit about when things go well and how we are proactive, but in some conditions where it doesn't go well, and what should we think about considering and thinking about some of the general principles for decision making. I think as well, too, I mean, there are many other legislations that really impact all of this, which I'm not going into today because we would be here for a couple of days, I think, if we think about some of the nuances of other acts that interface with this, considering such things as the Mental Health Care and Treatment Act, the Enduring Power of Attorney Act, the Neglected Adults, Child, Youth and Family Services Act. So all of these intersect when it comes to some parts of intertwine around decision making and really what is it in the context of healthcare decisions. I think that when we think about it in the context when we think about healthcare decisions generally, we base our assumptions on what does it mean to really have capacity and to really provide that consent. And when folks cannot do that and they're not have the capacity to make decisions for these types of events. When you think about competency in the biggest context, and we look at when we're assessing competency, there are some really nuances around that piece when we think about who actually can make and that healthcare decision and that test for competency in the context of healthcare. And when we think about competency in that discussion, we have to really, the person has to really understand that the information that they hear, that they have the cognitive ability to be able to understand that information, and that they understand the risk and benefits, and that they really can appreciate the consequences of that decision. Sometimes as well, in the context of all of that, well, that seems very simple in the way when we think about test for competency. It is not that simple because we have to ensure that the client really understands if I may want to refuse a decision, if I want to accept a decision, and that I understand and appreciate that everything that within that context is given to me so I can make that decision. I only today, for our purposes, pulled out competency and capacity, but there are other nuances when we look at elements of providing the consent, and I have to be competent to do that. I just have to turn up my volume. Can folks hear me now? I need to be a little bit closer to the mic. So when we think about that in the context of making, looking at that decision, we want to make sure that the client would have those types of things that are, that element that is there so that competency is determined based on the clinical assessment. And then there are other elements that I wanted to just touch on a little bit around what do we want to ensure that that the client has clarity around the information that is given to them, that they have an opportunity to have good communication. We don't want processes rushed. Lots of times I think, we could be under the assumption that folks understand and that we're reasonable communicators. But we all know, particularly in the healthcare context, that we know that gaps or lack in communication is probably one of our biggest failures when we think on actual fact that we may have translated that information in a clear way, but we know lots of times looking at our vulnerable population and that is not always the case. So if you think about what we look at from a competency and the elements of a valid consent, these are some of the things we have to take time to consider. Also, that it must be free of coercion and influence, that if I am competent, then that, that I know that that information is independent and there's no one influencing my decisions. Also, the information has to be also accurate. It can't be distorted or trivialized in any way. So all of those nuances is very important when we think about what needs to happen around intervention, particularly in healthcare decisions. And those, it also has to be very specific, right? We can't talk in generalizations. We have to be clear on not to exceed really what the scope of that intervention is. So if you think about it from that perspective, when we go in and we try to look at it being part of a healthcare team, and there is ongoing assessment of whether or not the client is competent, these are the things when we consider all of these elements in that reasonable way to think about. I really appreciate it. I really understand it as a client. I have an opportunity to ask questions, and that I'm not coerced in any way. I think from what we hear when we think about a client's experience, and if we are truly to be client-centered, we know lots of times from the client's perspective, like I said before, the whole piece around, are we communicating clearly? And do we really give enough time when we try to explain some of the things that are happening to our vulnerable clients, particularly when there are other things that may influence their capacities, such as illness and other things. So from that perspective, I think from social workers' perspective, to be an integral part of that team to really look at all of those factors when you think about what does consent mean in that perspective, that all of those elements have to be in place, and so then that we are confident that for sure that we look at informed consent, and that capacity and competency is really that pieces of it that the person has to understand, and that we know it gets a little bit complicated when the ability of that person or client can be impaired by other things, and that's what makes it in the world of looking at competency, and what does that mean in the context related to the client, and to be able to make those decisions which are critical for sure. So then when we think about determination, then, well, what does it mean if I'm competent or not? And that is why when we think about, most often it is the physician that determines if the client is not competent. And it is also important to understand, and from the perspective in clinical practice, that when that determination is made, that is communicated to the person. And again, focusing on client-centered care, we want to ensure that the legislation under the Advanced Healthcare Directives that really outlines when it is determined that that client is not incompetent, they also have a right to exercise, to get a second opinion to say, well, I don't necessarily agree. I won't go too much into that today for our purposes around what does that mean, but we know that, again, there's always that capacity there to make sure that that assessment is done as it should. So under the Advanced Healthcare Directives Act, it clearly states that each client age 16 years or older is presumed competent to make healthcare decisions. If not, they are to be assigned a substitute decision maker. And I think that when you look at the Act as it outlines in the Act around who that person should be and the category, it seems quite simple. But as we know, those things don't always go as they should. And specifically, what does that mean around the substitute decision maker? And if we think about, there are a couple of criteria that the Advanced Healthcare Directives Act tells us. It says that if I am to be appointed as a substitute decision maker, that I must have to be at least 19, and that typically we want to see that that person who is now that substitute decision maker is has had some contact with that person over the past year. Generally, that's some of the nuances that it tells us we should be looking at in the categories when we look at the substitute decision maker. And so it starts off in the Act that from the top, if we look at, so now we know that a client that we are working with in whatever area we are in the context of making some of these decisions, we start with the person's spouse. So the Act clearly outlines, which most of you would know, that the line goes that way. So you would have the person's spouse. If there is no spouse, you go to the person's children. Then it may be the person's parents, siblings, grandchildren, grandparents, uncles and aunts, nephews and nieces, or another relative. That is good. That clearly is outlined in the Act of who they should be. I think sometimes when I get calls and consultations from social workers in particularly, and we will talk a little bit about that in a few minutes, when then what, we do not have any of those folks. And what does it mean when we get down to the healthcare professional at the end, or the healthcare team? So the Act, while it clearly outlines those folks, it doesn't always work in the way that we would like to see it, for many reasons, for sure. So I think that if you think about it in the specific situations, and I want to talk a little bit about, particularly if we get down to families, and I know from situations that we've had consultations on, is that, well, we have a group of 6 or 7 or 8, and there is no agreement on who should take that role. Then what do we do? Lots of times, and I know as with social workers working as part of the team, we usually pull a group together and meet with the family and to get agreement on appointing a substitute decision maker. Well, how does that work? I mean, that sounds very reasonable, but as we know, in practice, it doesn't always work that way. And so we look at, then agreement has to be 50% or 50%, that we have to come to agreement on who is going to act as the substitute decision maker. And I think that while we want to get to that, that sounds quite simple. It doesn't mean we'll get there through our first interactions. And I think that with the skills of social work in particular, when we think about trying to navigate all of that piece, lots of times Social workers bring in other folks such as risk management, such as ethics, and others to really think, trying to look at consultation around that matter to come to some resolution. I think about in situations, for example, in long-term care, so if you're in that practice in particular, oftentimes if we've gone through all of that list, sometimes, not all, but in some situations there may be a family doctor that may be the substitute decision maker. However, if I require specific treatment, such as, I'll use cancer as an example, or something else, we may have to go to another person to act as substitute decision maker for that particular intervention. So generally, it works for the most part because, well, the act is not that clear. It says the healthcare professional who is responsible for the proposed healthcare can act as a substitute decision maker if we've gone through that whole list and there is no one. And so we know, particularly, and we're seeing some of this, and I've gotten calls from social workers around, we know that there are situations where there is no one that can act in that capacity from that list that we have, and that we get down to the person's healthcare professional. And also sometimes I know I've gotten calls from social workers that folks say, well, they want me to be the SDM as the social worker. I'm very happy to see that the NLASW has put out the guidelines for talking about such things as a substitute decision maker in enduring power of attorney, which is generally speaking mostly for financial reasons, and for SDM, that we social workers should not act as the substitute decision maker. So I really like that document, that is clear in that, because there are many nuances to, like I said, all of these acts that intersect, but it's not something, and I'm glad the document is out, because that has, I am sure that many of you on the line have been put into that situation in the past where you have been asked to be the substitute decision maker. So that really clearly outlines the ethical role in the accountability piece around the standard, and what not to do. So it's good to see those documents to provide guidance. Sometimes that doesn't make it easy in practice, but it will make it, I think, as on a go forward, to know that we have that document now as well. So when you think about it, the legislation is there to guide us. The pathway doesn't always go as planned, and I guess that's why, I mean, if you're in sole practice in the community as well, that's the piece of really consulting with others, particularly when you get into those nuances around now what, when there is no one available to act in that capacity. I think some of the things over time, what we have learned, and around substitute decision making, is this very piece of being proactive around our documentation. And I think more and more, as we think about it in the context of the work, whether, no matter where we are, if we work in community or long-term care or in hospital care, that I think people are tired of me saying around, well, what is our documentation, and is our documentation really supporting what should be there on a proactive basis, really, around SDM. And I'll talk a little bit about in a minute around next of kin and person to notify, and what does that context mean around a substitute decision maker. But It's like when we say, well, what are some of the failures? We think about, well, how do we improve our documentation, or how do we improve our communication? And I think these are two key factors when you think about how to be proactive in those ways when we see our clients, initial assessments are being done, and no matter where they are, either that to be children, either it to be in long-term care, or wherever it is around, is there good documentation, and do we have the documents that shows there is a substitute decision maker named in the event that I become incompetent or deemed to be incompetent. So I can't stress enough the importance of having good documentation, and it's the first thing. And when we engage in our consultation process, the first question that is asked is where and what type of documentation that we have. It may be absent, but also sometimes we also may have it. And it's important to be proactive, I think, into having those discussions. I know on the hospital side, I mean, there are, and I think around the province, lots of organizations have forms that folks can have completed proactively, and I know some of the assessments before long-term care, there's documentation there to have those assessments filled out in really appointing that person to act as an SDM. And really, when you think about it from a proactive way, really gets us into a good stead when we think about when we run into difficulty, when folks say, well, now that the person is incompetent, and now what do we do related to healthcare decisions? And I want to say here, really interject around talking about really what does next of kin mean, and in some instances as well, there are two things I think we look at clarification around. What does next of kin mean in the context of this, and the person to notify? So we gather that information, particularly if you come into a personal care home, a hospital, long-term care, and upon entering into that facility, one of the things we are asked is, who is that person that can be contacted in case of emergency? So folks give that name, and it's usually a person who has a close relationship with the client. But the next of kin is not considered to be a substitute decision maker as outlined in the Healthcare Directives Act. While now I say that, I mean, however, that person, if that is a spouse, for example, could be named if your documentation shows that they are the SDM. But when we look at next of kin, that's not what that information is gathered for. That person usually is someone that allows us, for example, under FIA, the Personal Health Information Act, that we can share information with, right? And that there is a close relationship to that person, but it's not considered to be the SDM. So as outlined in the Act for our purposes today. So I think lots of times there is confusion around that. We bring clarity to it. It's very clear, but not always. But I think historically it sometimes would get us into a discussion around that, and I think from social work practice it certainly does. The person to notify, which is also, that it's collected upon admission to wherever, it means that I'm identifying someone as a contact in case of emergency, in the event that we can't reach your next of kin. So again, It is usually a person. It may be a neighbor. It might be immediate family. It's a relative. But it's that person who I have a close relationship with, and it's acceptable that we take that name. Again, the person to notify is not considered the substitute decision maker as outlined in the Act. But, like I said, but they could be named if my document says that I have SDM named in other documentation. So I hope that brings some clarity around that, because it is really the sole purpose of collecting that information is that there is a person that we can contact on behalf of that client, and that if there is an emergency and that we need to connect with someone, then we have someone that we can actually notify. So I think the clarity around that, we do have lots of discussions and we get questions around that. But for the purpose of the Act, it's not considered to be the SDM. So I just want to bring that piece in here around those two pieces, around next of kin and around person to notify, because it really sometimes becomes quite complex as we try to bring clarity to whom actually is the substitute decision maker in the context of consent. Also, so I hope that brings some clarity to that piece for sure. And also, I just want to speak a little bit here now around children in particularly, and I won't go into the nuances, but it's also related to the advanced healthcare directives. And we could spend a lot of time of the nuances related to presumption of consent, particularly around if I'm over 16 or under 16. And the Act tells us that under the Advanced Healthcare Directives Act, that there is a presumption that children under the age of 16 are not competent to make their healthcare decisions. I'm going to say that, but there are particular cases, though, that we have evidence to say, in particular cases, we can reverse that presumption, right? And that person under 16 may give consent. But generally, typically, when we look at consent for children under 16, the substitute decision maker is particularly parents, and then it's a list of who that can be. And there are some nuances around folks that are under legal guardianship, or folks that are under the Children and Youth Care Protection Act. So there's some nuances around that of what we must follow around that, but particularly when we think about the Act, that's what it says that we must do, and follow those nuances around that, particularly when we think about intervention. So it's, and we could spend a lot of time around, even from that subset of groups, of the nuances around that, and we could do that at another time. But for our purposes today, I think that I'll just leave that there, and maybe there may be some other questions at the end. But if you think about, again, to be proactive from a social worker's perspective, that's part of a healthcare team in the context of where your practice is. The whole piece around, I can't stress enough around having good documentation, consultation with others when there has been disagreement, and that there has been some nuances that I didn't cover today that comes into the situation that has legal implications that we have to really sort out. It doesn't, always fit quite nicely in the guidance documents that we have, but I think that if we start off with having good discussion early, being very proactive around our documentation and good communication with the team, and also the communication that involves the family and the clients, because lots of times when we have consultations around that, some of the gaps we see after the fact when we're trying to figure out the pathways is really that miscommunication between family members, and if we're not proactive to try to do that, to take reasonable steps to really try to get us to a place upon agreement, it puts us in good stead to really try to get there, to be more proactive on some level. The other piece of it is as well is that when we think about some of the nuances around specific interventions, I think that lots of times when folks think they have, when we think about from communications perspective and from the client's perspective and the family's perspective, when we think about miscommunication, folks think that they have person that is a substitute decision maker when in actual fact it is not. And so then we get into situations where there are nuances around financial matters, so we try to tease out then really what are we trying, is it a will we're talking about, is it power of attorney, is it substitute decision maker? So all of these things, I think, if to bring clarity to the situation is very helpful in the early days of trying to sort out. Now, while that sounds simple, I know it is not when I think about folks who are in practice day to day, but these are some of the things that we need to bring clarity and to be really looking at, being advocates for our clients for sure, and to be really having good relationships, as you know, is critical, particularly around family situations when we think about to being proactive in that way, to really think about how do we work together as a team to get resolution to some of this. And as we know, there are many complex situations that arise that it takes a group of us for sure to try to get to a resolution, and I'm not here to say that it's all easy for us to do that, and the Act is one piece of it to give us guidance, but as you folks know in practice, there are many other things that causes us to reflect and think about how do we keep the interest of our client front and center, and then to try to come to resolutions, knowing that all of these other competing things are really at play here, particularly when you think about the steps that we try to get to, and to ensure that the client, the family, and us and the healthcare team understand that what is the goal that we are trying to achieve here, to ensure that all of this information is as it should be. So I can't stress enough the whole early intervention, good documentation and communication with the client and the family, and good team discussion and consultation. I realize across the province as well, depending on what type of practice you're in, you have to look in your local area to folks that you use for consultation, whether that be for ethics, for legal, through your association, through others, through team leaders, through as well. we also do some, I know from other health authorities, particularly some consultations on some of these matters, because they, as we are looking at what are the types of policies that are in place amongst jurisdictions, and looking at our kind of consistency and standardization. And so thinking about, I understand there are folks that are in sole practice and are alone, and how do you reach out in your local area to have access to some of those consultations when you are faced with some of these situations. I feel like I've been talking too long already, and I think that I want to stop there and to see if there are any questions or things. I'd like to have some discussions, or if I haven't clarified something enough, if folks can put it in the chat box.
Hi, thank you so much, Deborah. Great content, wonderful presentation. We are open for questions. There have been some that's coming in, so we'll get through those. But as we go through the questions, please feel free to keep the questions coming in. We have lots of time, and so I guess I'll start with one of the questions that we received. So this person says, in the Advanced Health Care Directive Act, it's based on competency. However, in the Adult Protection Act, it's based on capacity. At what point do you use competency or capacity? And is there a plan to have the legislation for advanced health care directives and adult protection to be more in line with each other?
That sounds like a legal question, but I will give my opinion. And it's a very good question, though, because you're right. If you think about it, see, all of the acts don't intersect, and that's why today, for this purpose, because as I started looking at all of our legislative requirements, so many of them do not intersect, because consent in mental health care and treatment is totally something else different. And also in the Advanced Healthcare Directive, and I guess, the neglected adults, when you talk about capacity, it's named only. And I think and I know in some discussions that I've had with our legal counsel and talking about some of the legislation and some of the intersects, as you folks know, some of those pieces of legislation have not been updated for many years. So I think I can only speak to when we think about the elements of consent using, we look at it to be kind of two layers, right? So we look at what it is in the Advanced Healthcare Directives Act for the purpose of consent, and then we look at all of the nuances around consent that need to be the elements of consent that need to happen, which is not legislative, but we know based on other best practices that we look at not only capacity, but many other things, as I talked about. So the specificity, the accuracy, the clarity, all of those pieces are really not tied to legislation, but are really important elements when we think about if someone says, well, did me as the client, I want, and us as the providers want to ensure that we provide all of those elements for valid consent. So I don't know if that answers the question, but the person is right, because if you look at all of those legislations that intersect, they don't always, because it's the different languages, interventions, and some of them haven't had amendments for quite a while. So I think it's a very good point it would be for sure in the best interest if we could have lots of the same language in those acts that intersect, right? So they all intersect in the work that we do. I'm just focusing on this one in particular, but I think that like I said, these elements I talked about are not tied to legislation. They're tied to when we did our standard document and our research and our literature review, were elements we needed to ensure that we have, and then part of that is related to competency and assessment of that competency and using the advanced healthcare directives to guide us when there is an assessment of incompetency. So I'm not sure if that's satisfactory, but that's and that is quite known that a lot of the language, if I looked at them all today and if we had someone to do a legislative review, they are right. They don't always intersect around even the same language and even around definitions.
Okay, wonderful. Thank you, Deborah. We have another question. This person is saying that they had a recent case where a resident was moving out of acute care, moving out to acute care from long-term care, and when the substitute decision-maker person to notify called the emergency department to get more information, the person was advised that they would not share any information with this person as she was not the next of kin. So how do we go about applying consistency and ensuring the right person is being communicated with throughout the organization?
Yeah, that's a really good question too. We've had those situations for sure. I think that if you think about on the other end of the phone, the person getting the call, and I understand it's very frustrating for the folks that are calling to find out about their family member. I think on the flip side, and I didn't talk about breaches, that also connects when we think about FIA, right? And so we want to protect the health information and not to breach anyone's privacy. So I really think lots of times we get in, and this is not to minimize the frustration of the family member, but it's really how do we ensure that seamless communication when someone calls and do I really know who you are? And with the kind of hesitancy is I don't want to breach anyone's privacy either. We haven't really landed to a way yet, even though we are, this is what causes a lot of angst because while we know reasonably, we also have that legislation as well, right? So as healthcare providers, we don't want to talk to anyone that we shouldn't. We don't want to share any information or disclosure of information that is not allowable under FIA. And but sometimes it does. I've gotten calls around those, and other than apologizing and trying to help them to navigate, it's really difficult because I think that we also have, so if you think about it now, right, I mean, the many legislative requirements that we have to act in the best interest, and then is that, okay, who is this person, and are you the person I should be talking to? And on the flip, we know that healthcare providers are very aware of, I don't want to breach anybody's personal health information either. Well, that's not very satisfactory for the answer, I know, but we have to, I think that sometimes gets us into those situations, particularly if I think the example was into an emergency department maybe, or even to an acute care unit. I think until they have that information communicated, again, it's that whole piece around being proactive, good communication, around having good tools to share that information upon transfer, again, being proactive. But I can see the whole piece because then I get folks calling me and then I'm involved in issues around if we have a breach, for example, which of course no one wants to be in that situation either.
Yeah, because this question was the substitute decision maker was calling for the information, but the ER wouldn't give it to them because they were not next of kin. So right, is it something with the language there, in terms of next of kin versus the substitute decision maker?
Absolutely. Well, there it is again, right? Because as I talked about before, like, are we having good documentation around? I know we use things like good share tools, for example, which or a transfer of information tool that tells us. I think, and this is where we get into the piece, because I've also been working with health records and others too, right? Because it's that piece. We still have that component out there that folks, and it's a big education piece, and we're trying to get at it bit by bit because they're right. So then I'm in ER thinking, yeah, I don't know if this is the next of kin, but then we take, excuse me, the next of kin, as I said, is not considered to be the person who is the SDM for the purpose of the Act. So again, it's about having good communication, right? So if I was to transfer, we talk about, again, when I talk about our documentation and our transfer, we want to ensure we have good transfer tools to give that information to. So in that, we should say things like, Debbie Perry is the SDM for. You see, because on the other end, we got folks still thinking again, and we have now, tried to clarify some of this through our policies, through our records management and health records, to say to folks, you have to understand that the collection of this information related to next of kin and person to notify is not the SDM. So I think bit by bit to get us out of that situation where we have those communication failures is the education component and good communication tools as we are sending or receiving and transferring. Is that helpful?
Yeah, that's good. Thank you. Still keep the questions coming in. We do have other questions that have come up. You did speak to this at the beginning of the presentation, Deborah, but someone has asked around, so who determines competency?
Mm-hmm. Yeah, so particularly in our world, competency assessment is usually completed by a physician in our world. In the hospital world for sure, and that we speak to that in, and I know in some situations psychiatrists do. So when we think about clinical assessment of competency, typically in our practice, that's what we do. I don't know about other practices in other types of areas, but in the world of, you think about decision making in the context of healthcare, it is usually the clinical assessment by a physician or a psychiatrist, generally in our world, and looking at what and the documentation around that clinical assessment around competency. Well, that may sound quite simple in some levels, but I think that, and I know out in practice in particular, we get nuances and which complicates matters more of that, well, I'm competent on some levels, but not on others.
Right.
So I can make some decisions. I think I can make some decisions related to my shelter, but I may not be able to appreciate and to understand the implications of other decisions that I can make. And so the nuances, again, around that's why it's so important to have good clinical assessment around the competency, the capacity, and what levels. Because it's not about taking away all of my decision making, right? That I can make some decision on some levels, but not on others.
Yeah, and further to that, just for folks online, the NLASW does have a document that was produced back in 2012, I believe, on social work and decision-specific capacity assessments and the role of social work. So if you haven't read that, you can certainly check that out on our website as well at www.nlasw.ca. And just while I'm on the topic of practice resources, before we get to our next question, Deborah mentioned in the presentation about the new document that NLASW has produced around enduring power of attorney, substitute decision making, and the role of social work, the guideline document. So that document is now available on our website under the practice resources section of the website, and that was just approved this month by the Board of Directors, adopted on May 3rd. That, as Deborah explained, goes through, the implications and discussion points around, when social workers do receive requests to take on those roles, and of course, because of the complexity of those requests and our guidelines for ethical practice and issues around boundaries and conflicts of interest and those kinds of things. Certainly, the guidance is around social workers not taking on that role, and actually the point from our guidelines for ethical practices states that in instances when clients lack the capacity to provide informed consent, social workers protect clients' interests by advocating that their interests are represented by an appropriate third party, such as a substitute decision maker. So our guidelines did provide some clarity around that as well. So that document is up on the website. So have a look at that as well under practice resources.
No, it's a good point, Annette, and I didn't get into too much of it today, and I'm glad you sent it to me beforehand, because to me it's very clear and very clearly outlines the accountability, which is helpful, and I know particularly for the practice here, it's helpful for me because I look at all of those documents from all the professional standards documents, because they come up in all different professions. And it's very good to have as a guideline for sure, and it helps us then as we try to work in trying to come to resolution of some of these, and from my perspective, I guess this is wisdom. I think of growing older, that we are getting more. I think complications around, particularly around clients that we see now in our world of being alone and with no one, and around what does that mean in the context of providing care, any type of care. So it has brought on different challenges that we haven't seen in the past.
That's right, yeah. Okay, wonderful. So we got another question that's come in terms of the difference, and I know you alluded to this at the beginning, but someone's asking about the difference between enduring power of attorney and advanced healthcare directive, and would a person need both, or could a person be both?
They could be. I mean, it's two different pieces of legislation. Again, I say I'm not a lawyer, even though people may think I am, but I'm just putting that out there. That the legislation of enduring power of attorney, generally speaking, are for financial matters. And I mean, there's nuances around that legislation that you can have a look at. I say generally speaking, and can they be the same person? They may very well may be, because I may have a document that talks about I'm appointing a spouse as my substitute decision maker, but they also can be my enduring power of attorney. But generally speaking, so you got to look at the legislation separately, right? So the Enduring Power of Attorney Act outlines all of the things as administrator that I need to do for financial reasons. So that's how the clarity comes with that. But yes, they could be the same person if I appoint them to be. Also, the thing about it, I think, and I've had this situation come up, folks, about signing documents, right? So, social workers call and say, somebody's coming in and want me to sign a document. My advice generally is no, and that we would, because particularly around legal documents, they could be all kinds of things. If folks want things witnessed or signed, they ought to bring somebody else to do that. So that's another thing. I know social workers have been put in that situation as well. Back to your question, though, they could be, but they're two different pieces of legislation. And if you look at enduring power of attorney, it's mostly for management of estate and financial matters that I appoint someone to be. And I could be the same person. But that's where I guess when I talked about before, it really has to be clarity around that, right? And around proactive, because lots of times too, as clients, they think, no, it's the same person, or aren't they to do everything? And then we talk about all kinds of other nuances when really by the time we try to tease out, really we think about, the substitute decision making is all about making it's really about the healthcare decision making. The enduring power of attorney is all about the financial. So,
and they could be the same person or two different people.
I may appoint somebody, and they could be the same person, but they have different roles. Yep.
Okay, great. So next question. When someone comes forward as a substitute decision maker to the healthcare professional, how do we clarify that they actually are the substitute decision maker to ensure that we're doing due diligence, that this person is actually the right person in terms of making the healthcare decisions?
That's a very good question. I think that I use the word trust, right? So it's like when we look at getting consent, we are trusting that the person that's coming forward, unless we know otherwise. So I use example of, for example, I'm the parent, so you tell me you're the parent, and unless we otherwise, contrary to that, we accept that to be you are the parent, right? So I guess the flip of that, the situation when we get into a little bit of difficulty is I'm not who I say I am, but for the most part, we trust that the person that comes forward, and like I said, with our documentation generally, that if we have that, we are trusting them that to be the person that who they say they are, and that unless we otherwise claims to be something different. Typically that works for us, right?
Yeah.
So if I say who I am, if I'm the child, if I'm the daughter, if I'm the sibling, if I'm the grandchild, it works for us generally, and that we have no other reason to believe that I am not who I say I am. Because then we're into another matter that's really a matter that's for another discussion around, other types of behavior that's not considered to be. But typically, we accept it to be, because if I show up and I say I'm the daughter, we don't say, well, can you show me the documents to say that you are the daughter?
Right.
Neither ask a parent that you are the child of this minor parent, because we have no reason to believe that you aren't. So we rely on that as folks. If not, it would stop our operations, right? Because we'd be going around looking to make sure that you're telling me the truth and you are the person who you're saying you are.
Right. So
if you think about that in the context, and generally, again, it works for us, unless it comes to a situation when we say, hold on, wait a minute, now we've discovered it's X and I am not the person, but if you think about our intent as the healthcare provider and as a social worker or whomever is a part of the healthcare team, we are taking in that information, right? And making that assumption that is to be, because if not, like I said, we would stop our operations and we wouldn't get consent from anyone, because we'd be going around to see. But we're off the assumption and the presumption, unless we know otherwise, that I am the person you are saying that you are. And with all kinds of things, as in documentation and other ways. But I've had very few situations, only on one hand that I can count, that the person then was discovered that I'm not the person who I say I am. Very rarely does it happen, And when it does, we address it accordingly to see really actually who has responsibility and the appropriate person to give consent, or then if it's a legal issue that we need to pursue further.
Mm-hmm. Okay, great. Thank you. Next questions are still coming in, so that's wonderful. Keep your questions coming.
Well, see, I knew I had to stop talking, right?
You wanted some discussion, some questions. Yeah. So this person is a wonder. So when individuals are placed into a personal care home or long-term care home, social workers working for these sites are often faced with being the first person or professional to discuss substitute decision-maker appointment and the Advanced Healthcare Directive. Are there any plans to further engage community assessors and acute care social workers in completing these documents at first point of contact?
Mm-hmm. Yes, and that's a good point, talking about contact and the first, because I think that while I think that particularly around social work in particular, that really are the first point of contact in many of those situations, we can't do it, and I use it to be the collective we can't do it without having all of those players. Because sometimes the nuances come around when we think we are doing our fulsome assessment, but we have all of these other players. So I think there's more work to be done, even though, as most of you know out there, the Substitute Decision Maker, the Advanced Healthcare Directive Act, has been around a long time, and can have some more clarity. But I think if it's the whole piece of, right, it's the movement too, right, I find, with the fluidity of the clients that are moving. If we don't have that same shared understanding, it becomes quite difficult. And oftentimes we do depend upon social workers because they are the folks that are lots of times the first point of contact around the assessments, and working with the families and the clients, and to be ensuring that we have that fluidity, which doesn't always flow as well as we would like it sometimes. But we're always having discussions with all of the program areas, really trying to think about how do we make that work, even from moving from then maybe acute care back into the community, or through personal care homes, or wherever they may end up to be, and even in looking at things particularly around with families, or if they are staying within their home and the supports around some of those pieces too. So, and the movement, right? So I think that it's really making sure that good documentation and discussion when you're one part of it, but a critical part of it. I can't underestimate that piece of it around those good assessments. And things change. I think that, sometimes we think about, and it does, and like I said, it's the fluidity, and it's the ever-changing and the complex environment. I think we still got a little bit of work to do on how do we try to, even the example or the other question about, I called up ER and they wouldn't give me any information, right? Mm-hmm. So how do we try to improve some of that fluidity? How do we try to really the criticalness of the social worker in that team is critical for sure. Mm-hmm. I don't know if I answered the question, but I mean we're always trying to making sure, it's all about, it's not only about do we know the policy or do we know the legislation, it's how is it going to work in practice, how are we going to operationalize it day in and day out.
Right. Okay, wonderful. I have another question. So this person has a client in acute care who was recently deemed to lack capacity when it comes to housing and accommodations, and the client has no family. The client did complete an advanced healthcare directive when the person had capacity years ago. The issue being that the person who was named as the substitute decision maker has not had contact with the client in almost 5 years. So does the frequency of, and I think you did allude to this earlier in the presentation, but does the frequency of contact matter when someone appoints a substitute decision maker through an advanced healthcare directive, and then what the process is following that as well?
Yeah, so generally, again, right, we look at to be that under one of the elements really that form a part of the Act is that we generally look at they have to have some involvement within 12 months. It's outlined there. But this is not a new issue. I know we've had that situation before where I have someone named, but I haven't really spoken to them or seen them, or they haven't been involved in my life for long periods of time. That's where we have consultations a lot, because then there has to be a few things have to be sorted, because that person who was then named, am I still alive? Do I still want to act in that capacity? So these are the things that we think about that may not even be relevant after time has passed. Mm-hmm. Is that, like I said, is that person even available right now to act in that capacity? And so I think when we think about from a good assessment of the time, that's where some of the nuances we have to sort out, because I may be moved, I may be outside the province, I may no longer want to act as that substitute decision maker. So that we do have those come, and then we have to sort out from there then to see, because there really has to be contact made too. Because I may have changed my mind, I may mm-hmm. not be available, or I may have some other something else that prevents me from acting in that capacity.
Right. And this relates to another question. In terms of age, how old does someone have to be a substitute decision maker?
The Act says we must be at least 19.
Okay.
Yeah.
Okay. That's clear.
Not many things in legislation, but some of these things are clear, and fairly clear. But yeah.
Okay, perfect. In terms of a child under the age of 16, what are some of the circumstances or issues that need to be considered in terms of children under the age of 16 providing consent for their own care?
Yep. So we could spend a lot of time talking about that one. It's always sparks great interest around if, when we think about it, again, I go back to, so we have to, again, determine if I am competent, if I'm under 16. So it's like we are saying I'm presuming that I am not. However, there may be situations that a person under 16 appears to be competent, that they may consent. It will be the same thing, though, right? That person will need an assessment of competency, as we talked about, and like, do I have the capacity? Do I understand what I am consenting or not consenting to? That so all of these nuances that we talked about, all of these things must be in place. We just can't automatically assume under 16 that I am competent to do that. Mm-hmm. And it requires that. So we know, for example, that we have folks that come to the ER under 16 that provide their own consent and that the healthcare professional who is doing providing the intervention determines that competency, and that is written as such. So all of those have to be in place around, if we're talking under 16, that these elements have to be in place, and then we determine it, that they can. So there are situations, and some folks would know in practice that that has happened. So if I show up to a clinic without my parent, that they can accept that I, as that minor person, appears to be competent, and that they may consent to the intervention. That typically works for us, again, the same, that we can have that documentation to allude to that fact, and that is quite acceptable to do. For the most part, though, and as folks of you know, generally, most folks show up with a parent if they're under 16, and we carry on as, and that parent and the capacity of that parent then provides the consent. But we have situations where they can, but it has to be good clinical assessment, good documentation around that competency, and that is as acceptable to do. I review a lot of charts around consent. I've been doing a lot of work around writing the consent policy for the organization, and reviewing lots of documentation and charts and files around consent. And generally speaking, we have lots of good documentation around that piece, because it's so important that as the healthcare professionals, we have all those elements around good informed consent to ensure that we provide that. So, short story, we can, but they have to be determined to be assessed to be competent based on all of these things around competency and capacity.
Right. Wonderful. And just on that note, stay tuned for the NLASW. I've been working on a document around informed consent with children and minors. That should be coming out soon, so keep an eye out for that. We'll certainly communicate that when it comes out through our electronic update, because it has been something that we've been getting questions around as well, and very similar to what you were saying, Deborah, in terms of all those critical pieces that need to be looked at when looking at determining capacity and competency for children and youth who are under the age of 16.
That's right, and so that's a good point. It'll be good to see that document, and we've tried to, from a policy perspective, so of course then we cannot do that without the Children and Youth Care Protection Act. So we've tried to put some nuances around that, particularly around parents and relatives, legal guardians, and children in temporary and permanent custody. So again, so that's pursuant to that act, which impacts around who can actually give consent for folks that are under 16, when there are all those nuances around that piece of legislation, and when that occurs. So we've tried to fit some of that in as well from a policy perspective to give some direction.
Great. Wonderful. Okay, we still have a couple more questions. A little bit of time left. We've got about 10 minutes left. We'll see if we can get through the rest of the questions. Time is flying. So the next question is around the capacity. Again, I guess capacity does change and can be fluid. Will the substitute decision maker only be engaged during those times when the client is not able to make healthcare decisions? And I guess, have you ran into situations where the substitute decision maker changes during those times? The person changes their mind about who their substitute decision maker is.
We've had situations where that has happened, and if you think about it, I guess when you think about capacity, if you use the word capacity in the sense of, I mean, when you think about in that context, there's all kinds of things that impair my capacity. So when you think about it from, a medical condition or emotional or a mental health condition, we have to ensure it's not impaired by that. And yes, if I have the capacity to authorize an intervention, or that I want to change my mind on naming a different substitute decision maker, if that is so and it's felt that, well, I am competent to do so, because remember, I have to be competent, right? Mm-hmm. That they can name somebody else. And that sometimes happens for all kinds of reasons. Like I said, the initial person may be not able to provide, to act in that capacity. So there are many nuances, and bringing, kind of that client to the center of that, of course, they have the right that if they have the capacity and competency at a certain point in time to make that decision, that certainly can, and we've seen that happen.
This is probably more of a legal question as well, but if maybe if you could provide some guidance where this person might access some information, or you might have some perspective to share on it. But in terms of the Mental Health Care and Treatment Act, so if you have clients who are asking, who are under that act but are asking about advanced healthcare directives, does an advanced healthcare directive outlining that the person doesn't want a certain treatment stand up in that within that context?
Yeah, I never reviewed that today, so I mean the nuances of that is very complex.
Yes.
And, yeah, so I mean that's for a whole nother webinar on Mental Health Care and Treatment Act and the nuances of that related to consent for sure, and particularly around consent to intervention. So I'll leave that one aside.
Okay.
That would be another webinar, I'm thinking.
Right. Okay. No, that's good. Thank you. The other question was around, sorry, go ahead.
I will say, though, just to say that from a policy directive, we've had some kind of policy guidance around that, around when a person is subject under that act and what does it mean. So we've put that in some policy direction, but I think it requires more than we can give it today in our last 5 minutes. I think about but they are very good questions around that act and this when the person is considered to be involuntary under that act. So I wouldn't give it service today for sure.
Right. Yep. Perfect. Last question, I think, unless some more come in terms of the next of kin, where they're not considered decision makers, what is their role when they're connected, or the team connects with them?
Well, clearly, like I said, the next of kin, it may be like I said before, the next of kin I have named could be my substitute decision maker, but when you think about it, when I come to a personal care home or long-term care facility or to a hospital or ER, the only purpose of collecting that information is that it's the person, we need to have somebody to notify in case of an emergency. So if my health status changes dramatically and we need to notify the next of kin. So like I said, it's the person who is contacted. It's meant to be in case of emergency. I want to, and like I said, it's usually a close relative, someone or someone who has a close relationship with, and it is considered that only, and is not considered to be an SDM as outlined in the Act, although I could have that person as my SDM, but it's really only collecting of information for that purpose. It is not considered related to that, which I think causes a lot of confusion. It does.
Yeah.
And like I said, we've been working with our health records folks and others because it causes a lot of confusion. But it's for that sole purpose. Like a person to notify, is that an alternate contact in an emergency? So I can't get your partner, husband, for example, but I need to call. Is there someone else I can call? Do you have another phone number, a relative? Some people may give the neighbor as a person to notify.
Right.
Not the SDM. It's not in that context. But I think where it's kind of collection of information that we have collected, but it's not. It's for really mostly for emergency situations. So if I just say my status, I deteriorated, for example, we need to get someone quickly, let them know to come in. I use that as an example.
Right.
That's its sole purpose. It's a person to contact on behalf of the client. I can't speak now on my own behalf, and it's in the event of an emergency, and it's not to provide guidance around clinical decision making.
Right. Okay, wonderful. Well, that's the end of the questions. So, and that's perfect timing because we're right almost at the end. So I do
have any questions. I'm really excited that we took us this time, and I'm really thankful for the great questions for sure.
Yes, it was a lot of good questions, a lot of good discussion. So I do want to take this time to thank Deborah for this excellent webinar presentation and for sharing her knowledge, expertise, and experience with us today. Deborah, you certainly introduced some important concepts related to consent within the context of the Advanced Healthcare Directives Act and how it relates to healthcare decision making. And as social workers, it's so wonderful when we can come together as a profession and learn from one another. I think that's the beauty of this, because it is through this type of knowledge exchange, reflection, and continued learning that we enhance our competency and strengthen our practices and decision-making in the best interest of clients. And in addition to being familiar with the legislation, we can also seek employer guidance and legal consultation when necessary to understand and interpret legislation relevant to our practice. Having social work colleagues like Deborah Perry to consult with is certainly very beneficial. I'm sure there's going to be lots of ongoing discussion following the webinar amongst teams and colleagues throughout the province. I do encourage everyone to complete the evaluation that will appear on your screen and let us know if there are other aspects related to the Advanced Healthcare Directives Act that you would like more information on, or any other social work topic that you would like to see as a focus for an upcoming webinar. Also, please feel free to touch base with me if you want to add your name to the roster of presenters for the upcoming year. I would certainly love to hear from you. So once again, the recording of this presentation will be made available on the NLASW website for future reference in the coming weeks. And just want to say a huge thank you to everyone for tuning in today, and a huge thank you again to Deborah for facilitating this webinar. And we hope that you enjoy the rest of your day.
Great. Thank you, Annette.